Hi, I'm Jane Baldwin, a sophomore with the Salvatore Center. Today, alongside Annie Deckey, I'm going to be discussing two cases that were consolidated for oral argument under the Supreme Court. The cases, Bostock v. Clayton County and Altitude Express v. Zarda, were heard on October the 8th, 2019. They both concern the same fundamental issue, sexual orientation discrimination under Title VII.
Hi, my name's Annie and I work at the Salvatore Center. In Bostock versus Clayton County, Gerald Lynn Bostock, a gay man, had been working for Clayton County in child welfare services for 10 years. In 2013, Bostock started a recreational softball league for gay men. After starting the league, one of Bostock's co-workers made a derogatory remark towards him regarding his role in the league and his sexual orientation. This happened in front of one of Bostock's supervisors. Following that, Clayton County launched an investigation into the fund that Bostock was managing. Clayton County found conduct unbecoming of its employees and therefore terminated Bostock. Bostock's case made it to the 11th Circuit Appellate Court. They overturned his case because they ruled that sexual orientation did not count as sex discrimination according to Title VII.
Just like Bostock, Zarda also seeks recognition of discrimination based on sexual orientation under Title VII. Unlike Bostock, Zarda is coming into the Supreme Court off of a win. In 2018, the Second Circuit Appellate Court ruled in favor of Zarda. In other words, they found that Title VII does protect against sexual orientation discrimination. This case pits Donald Zarda, a gay man, against his former employer, Long Island-based skydiving company, Altitude Express. As part of his job, Zarda would sometimes find himself strapped to female clients. In these situations, Zarda would occasionally share his sexual orientation so that the female clients had fewer concerns about being strapped to him. During an October 2010 jump, Zarda shared his sexual orientation with one of these female tandem clients. After the jump, the woman told her boyfriend that Zarda had inappropriately touched her and had used his sexual orientation as an excuse. The boyfriend shared her accusation with Zarda's boss, and Zarda was fired shortly thereafter. The legal question is if Zarda's firing constitutes sexual orientation discrimination under Title VII. Ultimately, in conjunction with Bostock, this ruling will determine if the Title VII phrase, because of sex, includes sexual orientation. If the Supreme Court rules in favor of Bostock and Zarda, then non-heterosexual persons will, for the first time, be protected under Title VII. They would have heightened job security and face less discrimination in the workplace. If the court rules against Bostock and Zarda, non-heterosexual persons may continue to face discrimination in the workplace, leaving them vulnerable and without legal recourse.